I don't know why y'all do that. Fine, we're going to start a minute early. I'll take it because I'll try to let you go a minute early. So I wanted to make sure that we get through our usual run today. This is Contracts Class 3. We're going to be reminding ourselves about the basic form of a contract. What is a contract and what's not a contract? And what contracts are is the law of bargained for exchange. What contracts are not is things that aren't bargained for, like gifts, or like doing something for somebody that they never asked you to do, or giving something back that you never were entitled to in the first place. And so we're going to start today to move from contracts as the law of bargain for exchange. We'll first do a bunch of work on advanced consideration, the doctrine of consideration, which is really the gatekeeper doctrine that the common law has used to say that courts are going to enforce with a special ferocity contracts that take the form, deals, that take the form of a bargain for exchange. And then we'll start getting into some of the things that they're not, but of course you'll immediately start noticing something about the things that they're not, which is that these are basically all just not only not contracts, there's a huge range of things that are not contracts. These are failed contracts, things that were supposed to be contracts, but for some reason or other didn't quite make it. And so we're going to see that these other doctrines not only fall outside of contract law, because if they did, I'd make somebody else teach them, but instead start getting brought back into contract law so that we can patch up things that were supposed to be contracts but weren't. So that's what we're doing in the class right now. We're going to follow our usual framework, which is I'll give a brief sense of where we were last class. We'll then flip it so that you have a chance to ask me any questions that you have about anything in the class so far. We'll do that briefly. I'll try to give you succinct black letter answers to your questions. It's great if in that time you're asking me succinct black letter law questions. If you ask me about philosophy of language, we're all likely to get a half an hour we don't need. So let's try to keep that succinct and focused, and then we'll move into the cases that we've got today. We have a fair amount to do, just really sort of wrapping up Eastern Airlines and moving into the rest of the cases. So before I do my recap, just any questions about what we're doing, where we're going, what's going on. I guess one other point of administrivia. It is time for us to nail down office hours. And I was hearing that there were some times on Mondays that would work. Is that right? Is there a time on Monday that particularly works for you guys? I can make it move one way or the other. But is there a time that's been sort of set aside for you all that you feel particularly comfortable with? Does after class on Monday work? Yeah. Okay, like that works for me. I'm not going to look that gift horse in the mouth. All right, sweet. We will then have, yeah, go ahead.
Would it be possible to also do one sometime after Wednesday so that if there are issues in the week, it's not already done?
I'm happy to meet with you after class on Wednesday, kind of as a general open invitation. I'm hesitant to schedule office hours as a regular matter because I teach AI that night and my brains are already coming out of my ears. But yes, I will absolutely meet with you on Wednesday after class. If you have questions, don't hesitate. Come out afterwards. We'll go up to my office. If you've got a study group, we'll do that. I just may have to call it short sometimes because I've got to prep AI.
Understood.
Great, thanks. Any other questions on administrivia before we get to our recap? Yep.
Will office hours be here or will you just go?
I'll go up to, the way it usually sort of unfolds is people have questions, they come up, we start talking about them, we move out to the hall because I start getting side eye from the next professor, and then we go up to my office. But they will be in my office, office 456 in the back of the Powell wing for the next hour after class. I think that's a good time for us to meet. Question. Anything else, y'all? All right, let's get going on it. So, we have been trying to figure out in a contracts class what are contracts, and we know economically, that is, they're one of two theories. They're either a theory that people ought to keep certain important promises that they've said they were going to keep, or economically speaking, that they often, but not always, but often enough, provide the opportunity for everyone involved to make money. And that because they do that, and because we can't tell when they do that or when they don't, right? Like if you see somebody out there, I mean, I know you've seen them, and both my oldest child and I have an issue. We like muscle cars. And so when you see, like MK and I both are going to see like one of those Dodge Challengers going down the road, and you know it wasn't a good deal. Like you know, and I'm sure I've deathly insulted someone in the room at this point, but like you know that if it was done for fun and you had the money, like great, that's what contracting's for, but we're not here to judge that, and that's the point, right? Courts can't tell whether something's a good deal or a bad deal, but when it takes the form of a deal, there's that opportunity for the economic magic to happen, and so because of that, then under the economic theory, courts are going to defend that with their life. Now, under both of these then, we have chosen to use the doctrine of consideration to act as a gatekeeper. And it's easy to see the way that consideration acts as a gatekeeper of the economic theory, right? It takes the form of something for something, and anytime we have a deal that takes the form of something for something, courts are going to protect and enforce it as a contract without inquiring as to whether or not the deal is a good one. In fact, in the cases that we'll see today, they'll in fact enforce it without even inquiring as to whether the exchange even took place. They can't tell whether a deal is a good one. All they can tell is it takes the magical form, and then we're going to protect it. Now, under our other theory of the cases, promise-keeping theory, it's harder to see how it works in the common law system. It's easy in the European or civil system because there we might say something like, all important promises under seal are enforceable, right? Because there what they did was they took a seal, they took something, they said, bam, this is an important promise. And the court's like, okay, you said it was an important promise, we're gonna hold you to it, right? That's promise-keeping theory right there. In the common law system, we don't have any such thing as all important promises under seal are marked and set apart. So what we start to do, and you'll start seeing this, take a look, this is a free gift for those of you I call on for Laporte versus Blum, right? Start watching how courts start turning the doctrine of consideration into a formality. Now, some people might think a formality is not important, but we are lawyers. Formalities are everything, because what a formality does is it takes contract law and it says, are you outside of the pocket universe of law we have just crafted? Or are you caught, right, with Dr. Strange inside it already? Like, are you trapped here with the rest of us? Are you caught inside that? That boundary is really important. There's a hell of a drop there, right? That's a step. You got to watch it. Either you're bound by the contract or you're not. And so the formalization requirements of contracts are a hidden part of common law contract. I'll say it right now. You'll forget it, but it turns out to be really important. There's a bunch of things that we're going to start doing that most people out there think are a key part of contracts. One of them is get a writing. I'm going to ask you right now, because the right answer is important. Do you need a writing to enforce a contract? No. If I say I would like to sell you these glasses, and you say I would like to buy those glasses for $17.99, and we shake, do we have a contract? Absolutely, we have a contract. Offer, acceptance, and consideration. That's what it takes to form a contract. The writing in the common law system is a formality. It is a formalization requirement. It is a way that we tell people, you have now entered the contract zone, right? You've now entered that delineated zone of alternate reality in which we have created a bunch of laws that apply to us now. The reason that I raise this now, this is not the topic that we are looking at right now. In this class, we will look at contract formation, contract formalization, interpretation, defenses, and remedies. Those are our 5 questions. What I've just said is going to be part of contract formalization in a minute. But because the cases that we're looking at today have these formalization requirements peaking up already, you had to have a writing in Lucy versus Zamer. Why? Because contracts for land are one of these important promises that we have to get in writing under the US, under the common law system. Similarly, when we get to Midwest, right, the reason the franchise agreement has to be in writing is because it's a contract that can't be performed in under a year. And that is required to be in writing under the common law system. We will get to all of that later, but what I want you to realize right now is that the doctrine of consideration, which is what we are studying, is not just used as a doctrine defending our 2 types of contracts, keep your promises or we could all get rich, right? I don't care what theory you use. Consideration is not just used as a way of setting apart those things. It's a way of marking the contract. It's a formality. It's a magical ritual that is different from reality precisely because it warns everyone we are about to enter into the contract zone. Now, what weird ritualistic action from the cases that we've already done, what weird ritualistic action did one of the parties take that you're like, oh yeah, I get it. The $5. What the living beep was the $5, right? It was this devotion to the god of contract, right? It was just like, I'm going to do my magical ritual. I will cast my spell, right? Boom. We know that's what he was trying to do. He was using that $5 as part of the ceremony of contracting, not as the contents of the contract. Nowhere in that deal was, it was the farm for $5. That was not the deal, right? What he was trying to do was formalize, make it official. Remember when he said make it official? He wasn't dumb. Lucy versus Zamer is a great place to see this difference between contract formation, which is what we will do first, under the doctrines of offer, acceptance, and consideration. We do consideration first, then we do offer and acceptance. That's formation. But it also gets you then set up to see the arguments about formalization that are coming on down the road. And you'll need to get that for the stuff today. Now, with respect to Eastern Airlines and what we just finished with, it was this, that contracts are best described as something for something. That's the doctrine of consideration. Notice, it's not a benefit or a detriment, Carlyle, when we get to it. That's a freebie for you. It's not a benefit or a detriment, right? It's literally a bargained for exchange of promises. Those promises don't need to have happened yet. I will pay you $17.99 for the glasses. Great. I will convey the glasses to you. Both of those are I will. Neither party has done anything yet. A valid contract is formed. Something for something. But then we began to run into the problem of some contracts take the form of something for nothing, if you poke them. Now, sometimes it's easy to poke them. And we talked about illusoriness in contracting. That's restatement 77. And we said illusoriness in contract occurs broadly when one party has made no promise. And the way that that occurs in reality is when one party has appeared to make a promise, but that promise is conditional on an event that is fully within their own control. And I kind of gave you the Fairfield take on illusoriness. Now, you have to be careful about illusoriness because once you see it, you start seeing it everywhere, right? Every condition starts to feel illusory. And in fact, that's exactly what happened in Eastern Airlines. Like they took a contract that was perfectly straightforward, and in the whole framework of industrial contracting, you needed this kind of requirements contract, which we looked at. But Gulf's argument was, this is essentially fake, and this is where we'll start off, and I'm going to kind of start off with Lucas, and we'll talk about that, but I want to make sure you get your questions first, then we'll start off with that after the break. That it's essentially fake. That was their argument, because if your argument is, if I need fuel, I must buy it from you, has got an if in it. And in fact, if you have no requirements, then the amount of fuel you buy is none, right? And that then, that's that temptation, right? Illusoriness everywhere, that you begin to see all of the ways in which conditions and excuses and other things in the contract might let somebody out of the deal. Now, I gotta say, once I've told you to not see illusoriness everywhere, the graduated version of this is you keep it in the back of your mind, because there are some really, really complicated arrangements that we will see in some of these future contracts, including a case by Judge Easterbrook that's coming up, in which the parties have made all kinds of promises to each other, but there is one loophole for one party, and the court's like, nope, gonna let them out. Gonna let them out of the deal because that is an event that was fully within that party's control. They controlled it. They decided whether the event was gonna happen or not, and therefore the whole deal was functionally illusory. So we've taken this old common law contract doctrine of illusoriness, we then applied it to explain why, and this is black letter law, at common law contract, requirements contracts were not supported by consideration. But you can see how in an industrialized society, you need the trucks and the factories to be going. And in a long-term contract, the amount of stuff you need every month is going to change every month. never mind over a period of 20 years. And so you've got to have this flexibility. Therefore, we begin to see the change in the law, where the common law said requirements contracts were iffy at best. The Uniform Commercial Code said, nope, 2306, they are absolutely fine because, I wanted to save this to ask you afterwards, but I'll just tell you the question. I do want to make sure other people think. Because it was, your requirements had to be bought in good faith. And I'm going to ask you to unpack that argument when we come back. All right, so that's where we were, and that's what we're doing. Is there any question that anyone has on any case or any doctrine, anything that we've done in the class up to this point? Y'all got it? Real short question and answer session. Going once, going twice. Fantastic. So let's move on then. What is it that makes this idea that we're going to update and change the law? And this will happen a lot in the Uniform Commercial Code. When you start asking yourself, hey, on the final exam, Professor Fairfield's asked a question, and in this question, I'm not at all certain whether or not this is about a good or a service. In fact, it's fundamentally ambiguous. He's written the question, so I can't tell whether it's a good or service. What I can tell is that there's a real problem with this option. This option is not supported by consideration. And what you'll decide most of the time is that's fine under the Uniform Commercial Code, and it's not under the common law, and that's the nice fork in the road that I've given you. And you just say that. You just say, look, this is fine under the common law, and it's not. Sorry, this is fine under the UCC, and it's not under the common law. What is the reasoning why a requirements contract, which could be, I could say literally, I will buy fuel from you as long as that is what I require. Why does that satisfy our ideas of consideration?
Well, if we didn't have requirements type contracts, then the whole sector wouldn't work because you, like you said earlier, you don't know exactly how much you're going to need. So you don't need consideration in the strictest sense, but basically for a requirements contract to be valid, both actors need to be acting in this good faith, and that's kind of, I guess, the substitution for consideration
Right.
in this type of contract. Do you want to hear why I think that they're not operating in good faith?
Yeah, well, because let's pile in then, right? If the court's right, saying this is a promise for a promise, it's not an empty promise, right? A promise that I make that I will fulfill if I feel like it. That's not a promise. You with me so far? So what we're trying to say is no, these requirements contracts maybe can be, although then you've got some questions about good faith, right? Maybe can be supported by saying this is a promise for a promise. I'll ask you about good faith in a second. What is the promise for a promise? How are these parties constrained here? They can't just do whatever they want. They can't just buy or sell fuel if they feel like it because...
So they're both, well, I guess both they agree on price. So that's the first promise of that contract.
Right.
And then the second promise is when Eastern is at that facility, they will use Gulf's fuel. Basically, they have to buy from Gulf when they're at that facility.
Right.
And then Gulf's promise is that they will sell to Eastern when they want their fuel at those facilities.
Right. So if I buy fuel, meaning if I run my business, I have to buy it from you. And if I sell fuel, I will sell it to you at this price. It does look like there is a promise with a promise in a promise. Another way of saying it is, if I say to you, hey, I will buy your house if the termite inspection report comes back okay. Have I made a promise? I'm seeing a no, I'm seeing a yes. Tell me about the no.
You haven't defined what qualifies okay. It's totally subjective.
Sure, so it's totally subjective. What's the yes, I have made a promise?
Yes, because I feel like with something like a termite inspection for a house, it'd be a pretty standard thing for you to say, hey, there are termites or there are no termites.
There are industry standards here, right? And we're going to rely on whatever a termite inspector would generally say within this framework. So here's the point. There is a loophole. There's an out. Not every out means that there's no contract, right? It's not that there's an out. It has to do with whether the out is going to operate purely at the discretion of one party or the other. Now, let's talk about that. So we now know why good faith can act as consideration. Now, it's a modern understanding of consideration, if you think modern is 1950. right? That is modern in the sense of literally the term modernity, the post-war framework of broad-based industrialization that creates the need for these long-term supply contracts. Did you like the courts sort of pontificating about the jet age? I thought that was a nice touch in this case. Like, we have gone back a minute in time. Now, tell me about why, though, the real argument in this case is, as you point out, whether this is in good faith or not.
So, as a result of our contracts making our fuel prices really low, the Eastern Airlines is fueling up more than they would normally at our fuel stations, and then not fueling up anywhere else because our fuel is super cheap. And we think that that's not good faith.
Right. So we think you're fueling up on us and then freighting it around to other airports where you don't have this contract, right? So that you can buy cheaper fuel. And I mean, Blue Ridge Bucha probably thinks that. They have terminated my kombucha deal as of the last month, in which if you brought back their empty bottles, you could get them refilled for $2 each. Now, last time I showed up with 19 bottles, which was a case and a half plus one to drink on the way home from picking it up. And you could see like the desperation beginning to grow. They were like, all right, look, at some point, they're cool. By the way, was it in bad faith to fill up 19 bottles at Blue Ridge Bucha? What additional facts would you want?
What are you doing with the kombucha after you fill it up?
Yeah. In fact, tell me the two things I could be doing with the kombucha.
Are you either consuming it yourself,
Or I'm-
I don't think it would be in bad faith.
Yep.
Or are you selling it at a higher price?
Right? Look, the stuff costs $5 at the Martin's grocery store. You see the problem if they're selling it to me for $2, right? At some point, they're wondering what the hell I'm doing. So you can see good faith does have a meaning. It's not like it's just this empty, let's talk about our feelings. Where do we get good faith in a given conflict? Where do we get that idea of good faith?
I mean, there's a definition for it, if that's what you're asking for.
Sure, but what's the definition for it? Because then I'm just going to ask you the same question again. You're doing the right move. What's the definition?
Honesty in fact and the observance of reasonable commercial standards of fair dealing in the trade.
Right. Oh, by the way, love it, write it down. The definition for purposes of the Uniform Commercial Code of good faith is honesty in fact and the observance of traditions within the trade. Hey, what split in this class do those two parts of that standard mirror? What is the difference between commercial standards in the trade and honesty in fact? In the back. Common law versus UCC. First of all, let's be clear. This is a definition for good faith that is in the UCC. We come to it in a different way. We come to it because that is what the Uniform Commercial says in 1201, the definitions section. We do not come to it through a process of reading a bunch of different court cases and then kind of homogenizing them and saying, hey, what does good faith seem to be across the range of cases? So you're right, there is this UCC versus common law split here. There's another deep difference though. Yeah?
Objective versus subjective.
Love it.
versus conduct.
Well done. What is honesty in fact? That is, are you in fact telling the truth? What side of that is that? That's subjective, or whether or not you're telling the truth or not is entirely subjective, right? Now, what about the observance of standards of commercial good faith and fair dealing? That's objective, and we look to the industry. In the Uniform Commercial Code, you will almost always do both. I'm here to tell you of which of those two do courts like more? David. They like the objective. They like the industry. They like the industry practices. Why do they like it better?
Because it doesn't require like figuring out what one's intentions are.
Right, because it doesn't require, for example, someone might be lying but not know they're lying, although then you might say they're not lying. And at that point, they're being honest in fact, even if they don't have all the facts in front of them, right? And it can become impossible for them to tell whether the person, and what if the person's telling the truth, but they thought they were lying, right? There's this whole series of questions that come under it. Courts hate it. What that means is, unless they're forced to it, they're going to stick with the objective standard. Fair enough. And what's the objective standard look like in this case, Lucas? The objective standard of the definition you've just given me is?
Oh, that's like the fuel freighting.
Fuel freighting. And then talk to me about that. And like I want you to stick to your guns and say, nah, this is still not good faith. This is still closer to me going and getting the bucha to sell to other people than it is using for my own consumption, right? Like you can still say that, but what's the fuel freighting framework here where the court says, look, good faith it does constrain you. It means you have to think you're telling the truth. That's subjective, right? That's honesty in fact. And then you have to be following these industry best practices. Take it away. What are the industry best practices here?
The industry best practices, I guess, have changed in the last, or they've stayed consistent in the last 30 years in the fact that it varies when you fill up, like based on weather or based on prices.
Yes.
So basically, it's been changing. Am I supposed to argue for golf? Because that's kind of hard for this, because they're doing it pretty much standard best practice.
And also, like the single worst thing about this entire problem for golf is what on that point?
It's the fact that when Eastern has bought massive increases before, Gulf has never complained.
Yeah, Gulf never complained. Also, do you notice who wrote the contract?
Gulf.
Yeah, it's Gulf's standard contract. This starts getting harder and harder. It's not just that Gulf wrote it, it's that it's Gulf's standard contract that incorporates standard provisions, right? This is starting to look like industry custom and practice. It's pretty hard for Gulf. I agree, it's a hard one to argue, but let's go ahead, we get paid, right? So let's give it a shot, This is, nope, still bad faith here.
So it's bad faith because we've seen like a massive increase basically, and we haven't seen that increase from, or in their buying from other sellers. So that implies that they're coming specifically to us because we're locked into this contract. And then that's bad faith because they're basically abusing it, and it's not industry practice to ignore another buyer for a specific buyer.
Right, and then the pushback to that is, why are they ignoring the other buyer because of this specific buyer? They're ignoring other sellers because of this specific seller. Why are they doing it?
Cheaper.
Yeah, it's cheap. Like if the price is lower, it's really hard to argue. Notice though that your point really starts to get some bite if, as we see in some future cases, and this is where we'll leave it, it turns out that one party knew the other party was making a mistake about the index that they were choosing and chose not to raise that at the time, right? At that point, you start saying, you were the one that could have raised it. You were what's called the cheapest cost avoider. You were the one that could have raised the issue at the time. To not do so means that we're going to interpret the term in the way that the other party understood. That's Restatement 221, for example, if you want to go take a look at it. Okay. What I need you to understand now is requirements contracts under the common law were traditionally not supported by consideration. That doesn't work in modern technological societies. So the UCC changed that, and to do that, they also changed the standard interpretation of what consideration is. It is merely a promise that has some bite, even if there are loopholes, even if there are big loopholes. As long as your promise has some bite, then it is a promise that can support another promise. That is our basic framework of a promise for a promise holds. The bite here is they do have to perform this contract in good faith, but your immediate response, and Lucas's immediate response is, what does good faith even mean? But then we looked it up, we found out what it meant, and it still does seem to have some bite. You can't lie, and you have to follow industry best practices, which means that when Gulf was complaining about fuel freighting, it wasn't that fuel freighting was cool, it was that everybody else was doing it that saved their bacon, that saved Eastern's bacon on that particular move. All right. Any questions about Eastern Airlines, why we're studying it? It's our UCC case on consideration. We're also using it as one of these cases that is showing the development and mutation of the law. You should be able to see how the doctrine of consideration has now moved a long way from Hamer versus Sidway, benefit or detriment, to become Restatement 71, all bargained for exchanges are enforced. And now we're beginning to see the problem of certain things that take the form of a bargain for exchange, and we're going to question whether they really are or not. And that's what's caused the consideration doctrine to shift as we move from the mom and pop cozy core economy up to the post-war industrial model economy. Expect these changes to continue as we move into the software economy and the data economy, the economies that followed. Any further questions on any of that? Yeah, go ahead.
Sorry, just as a clarification.
Yeah.
Is requirement contracts an exception to the illusory?
To the illusorianist rule.
Yeah.
No, but because there are other ones in the UCC that are, it's maybe useful to talk about it. So it's not an exception to the illusorianist requirement. Remember when I said, once I teach you about illusory contracts, you're going to see them everywhere. A requirements contract is not an exception. The courts are saying here that requirements contracts are not, or by the way, an output contract would be the same for the seller, right? A requirements contract says, I agree to buy all that I need. An output contract is, I agree to sell all that I have produced. Same deal. Why are these not illusory? Illusory would be, it looks like a promise for a promise, but because one promise is founded on a condition entirely within the control of one of the parties, it's actually fake. That promise is fake because it's got feet of clay because the person doesn't actually have to follow through on that promise at all. These aren't illusory. Requirements contracts aren't illusory, the court says. Why? Yeah.
Because it's saying you're not fully in control of whether you have need or not.
Right? For example, give me a set of circumstances, Lucas, in which this would be clearly bad faith. Like, I mean, I understand you sort of played the best cards you had, right? And you kind of rode that horse as far as you could. But now I'm going to give you the chance to kind of open it up. Maybe my Bucce example would give you an option there. Like, under what circumstances is this just like obviously bad faith?
If they just started like driving trucks to our facilities and filling them up and then going to other places and selling our fuel for twice the price.
Okay, you get the point, right? Like, do you see, it's not hard to imagine a world where we're like, no, Eastern is what? That's the other problem. If a contract is illusory, what's the remedy? We're going to jump to the end of the class. What's the remedy if a contract is illusory? What does it mean if a contract lacks consideration? You have to always watch out for this one. Yeah. There is no spoon. There is no contract. You have to watch that one. Because sometimes the person that's arguing that it's illusory, you look at it, you're like, do you really want to argue that? I don't think you want to argue that. Because if you do, I'll give you an easy one, right? Sometimes people will argue that, for example, certain online contracts, you don't have capacity to enter into them. But you need the contract in order to not be a copyright infringer. So do you really want to argue you didn't have capacity to enter into the contract? Because it turns out breaching a contract is bad, but is nowhere near as bad as like, $150,000 per willful infraction, which is what you get as a copyright infringer. You don't want to do that. The remedy here in the sense is the contract never existed. What is the case if Eastern is filling up on Gulf gas, using its planes as tanker trucks to fly to other places, draining the fuel out of those tanks to, I don't know, Southwest Airlines. Eastern Airlines doesn't exist anymore, so I don't know what other airlines didn't exist at that particular time. I was barely born. And they start selling that off. That's clearly in bad faith. What is that called? That's not the contract doesn't exist. That is breach of contract. Can you see the difference? Illusory means the contract's never there. Twilight Zone, it's not there, right? You thought it was there, but it's not. This is breach of contract. So again, we can see, because we can imagine a world in which Eastern can be in breach, in which the promises that Eastern made, in fact, did have some bite. They did mean something. There are worlds in which they can do whatever, they can't do whatever they want. If they do some things, we know they're acting in bad faith and therefore they're breaching the contract. And that becomes pretty good evidence that this contract is not completely illusory. And the fight has to be where Lucas took it, which is this bad faith or not? That's where we have to fight. We can't fight on the grounds of, is this illusory or not? So that's a long answer to your question. These requirements contracts are not illusory. They are considered a promise for a promise. The real question is, does the requirement of good faith give their promise enough enforceable bite where we say, yeah, okay, that was actually an exchange of something for something? And the answer is a resounding yes. Nate.
Yes, just to follow up on that. So, like for the UCC, if the promise has some bite, in this sense, that bite could be good faith.
Yeah, that bite is good faith. It's not could be good faith. The doctrine of this case is that 2306 is saved from the doctrine of illusoriness, that 2306 works because the good faith requirement means that that Eastern has actually really made an enforceable promise. That they can be held to it if they breach it. And then the question is, did they breach it or not? That's the real fight, as Lucas points out. Yeah.
In this case, if they had been found as breaching the contract,
Yeah.
what would the damages be? Would it just be like the difference in?
Well, who? Eastern or Gulf?
Sorry, Eastern was found to be practicing in bad faith.
Yeah. Oh, damn it, man! Why you gotta ask good questions? You make me hurt you. Okay, so we skip to the end of the course. Remember when I've been telling you the whole damn time that these things that we're about to study, and this is actually a good moment for it. The whole time these things we're about to study, reliance and restitution, are not just their own theories, but they're also theories that keep getting plugged back into contract law. Let's just be a human for a second. What do you think the remedy should be if I buy Bucha at $2 and I'm out there selling it at $4? What should the remedy be? And I make, say, $100,000 doing that. What should the remedy be?
I don't know. Like it just depends on your perspective. Because how much did it cost me to make my $2 Bucha?
Well, you still made some profit. Like they're not selling it to me on this special for nothing. Like they're not selling it at a loss. Yeah. And that's called disgorgement. The remedy in a case like this would be disgorgement of the opportunistic gain of property, the gain that you get. You have to disgorge something that you received, which it was unfair that you received. Is that the expectation measure of contract damages? No. What is that at the end of the class? What is it when you say, you have received something that is unfair to let you keep? You're going to have to give it back. It's a remedy. Which of our three remedies? Restitution. The answer to your question is, functionally speaking, the breach of contract remedy for something like that looks a whole lot like restitution. If it's not restitution, it's like its immediate doppelganger. It's disgorgement of these profits that they got through the opportunistic breach of contract. And that is why we teach these doctrines of reliance and restitution in contracts class. It's because they can't just be somewhere else. They got to keep being pulled back in and keep being used. And that's one of the examples of that. So the remedy would be they would have to disgorge the profits that they received. And you can see why. Because let's say that it was something less than the $100,000 that I made doing it. What's the problem with a remedy of $25,000?
There's still $75K of profit for you to just keep doing it.
I'm gonna keep doing it, right? Do you see that? Or somebody else is gonna do it. You gotta have that disgorgement remedy, otherwise people are just gonna keep doing it. Great point. Okay, any further questions on Eastern? Cool. Then let's clean up a few things on Harrington, which is not all that hard, and then move into advanced topics. So let's see here. We'll just kind of do this as a one-off and then back and forth. Skylar, would you mind setting up Harrington versus Taylor and sort of extra if you talk about Webb versus McGowan a little bit as well? What's going on in these past and moral consideration cases? Yeah. Yeah, me neither. Tell me more.
So the defendant, Karen, assaulted his wife and somehow ended up in the plaintiff's house. And it just, the defendant knocked out the wife, I assume? Yes. And then they were going at it with one another, and the wife was going after the defendant. And the plaintiff got in the way of that. So then the plaintiff got injured in there. The defendant promised verbally that he was going to pay out the plaintiff. However, that never happened.
That never happened. Right. And then he sues. And there's another case called Webb versus McGowan that goes the other way, and I hesitate to even talk to you about it because Harrington versus Taylor both will stick in your mind. Right, the axe-wielding spouse is, enough to make anybody remember a case, which I presume is why this is still taught in textbooks. And I'll ask you in a second, Scott, like, why is this a question of consideration and what's going on here, and what does that matter? Webb versus McGowan, though, was a similar thing, right? There was a factory accident, a block was swung out, somebody leaped out to protect a person, pushed them out of the way, the block fell on them, the person promised to take care of them in response for that, and the court did enforce it in Webb versus McGowan, which makes you, I guess, get to say on the bar exam and in your own mind, like, maybe this could be a thing, but in fact, the restatement does follow that. The restatement says that a contract based on past or moral consideration can be enforced to the extent necessary to avoid injustice. I'm here to tell you, the restatement's wrong on that. Webb versus McGowan's just not a thing anywhere. The rule really is Harrington versus Taylor, and we got to figure out why. Even in these incredibly sympathetic circumstances where somebody saves your life, we do not treat it as a contract. So, why? Why is this a contracts case? Why is this a consideration case? And why don't we apply consideration here? Well, the court says what in Harrington?
It says that it's a matter of opinion. So what I got from it was that it's a consideration case because he acted within the moment of saying that he was going to repay her. Because it was like a heat of the moment kind of situation.
Heat of the moment kind of situation? Yeah, go ahead. That's the basic argument. You can't bargain for what you already have. Tell me more about that.
The plaintiff did that of her own volition. He never asked her to do that, and afterwards he just said he would do that. It's nice that he did that, but he wasn't required to do it. They never agreed beforehand. It was just for the moment. I'm just being a nice person because you were nice.
Right. So the idea here is that it's exactly what Schuyler raised. Right. The question is, can you come to an agreement? Like, you imagine if she'd have been chasing him around the kitchen with the axe, right? And the guy turned to the plaintiff and said, "Save me and I will pay your medical costs for the rest of your life." We might raise something like a defense of duress, but we won't make this argument that it wasn't bargained for. There's something about past consideration that sets it apart if we take the doctrine of consideration under which of our theories? Because under one of our theories, this makes no sense, and Webb versus McGowan makes all the kinds of sense. Right? Under the other of our theories, though, yeah, we get it. Yeah, go ahead.
Under the social theory, maybe it would make common sense.
Yeah.
Why did you break a promise like that? Especially if you saved my life, but then for the economic thing, it's like completely falls apart because it's the past consideration thing. So you already have something who benefits. It doesn't really make.
Right? You can't have that bargain for exchange. And remember why we've got such a thing for bargaining. Why do we have such a thing for requiring the exchange to be bargained? Let's be clear. Was this a good bargain? Yeah. Yeah, both people live instead of one dying. That seems to be a big darn deal, right? So this was a good. Do we want people to behave like this in our society? Seeing mostly some head nodding. I have questions about those of you who are shaking your head. I have views. Right? We want people to try to save each other. We want people to try to save each other. Why are we hesitant, though, to encourage that behavior through contract law? That's a different move. Yeah. Ben.
Because it might make people stop helping others.
Yeah, tell me about that. I mean, actually, by the way, that turns out to be the law. In tort law, you done that yet? You done Good Samaritan laws? Yeah, well, I mean, so if you're a doctor and there is a wreck on the side of the road and someone badly needs medical assistance, call your lawyer before helping. Because in many states, there are Good Samaritan provisions that shield you from liability. But in other states and under the old common law, once you intervened and took control of the situation, you were on the hook if you did something negligent. And we're like, no, we want people to stop. We want people to help. And so arranging it this way might stop them from imposing legal rules, right? What happens if he hadn't saved the guy's life? What's that called if we take this as a matter of consideration, if we took it seriously? What's that? Negligence. If we were in that classroom. Breach of contract if we're in this classroom. Do we really want, like, can you imagine the scene, like the guy's running around the table, right? The axe is following him. Do you agree to do this? Yes, but under what circumstances? What if I fail? I don't know. Like, we'll have a loophole if, like, I'm under the table now. Right? This is not meant for contract law. Contract law is meant to create this special universe of law because the parties have had a chance to tell the court and each other the special things that they needed and wanted out of the deal. And if they haven't had that chance, because of this, as Scholar points out, sort of heat of the moment kind of problem, it's not bargained for. Even if it's a positive exchange, even if it's good for society in general, even if it is efficient, even if the parties agree after the fact, even if they agree after the fact, I would rather have saved your life than not have saved your life. Benefit. I would rather have paid you for the rest of your life and taken care of your medical bills than be hit with an axe. Right? Still our bargain theory holds the line hard. So that's what I need you to know. Past or moral consideration is not consideration for a common contract in the overwhelming majority of cases. Every once in a while, you might see a court kind of tempted by Webb versus McGowan. I think we try to still teach people that just because there are some alternative cases out there and you can really tempt a court to spread out the negotiating process to try to claim that some of it happened at the right time in order for this to really be a bargain for exchange. But in general, we require bargain for exchange, and this is just another example of that. Any questions of past or moral consideration and the Harrington versus Taylor or Webb versus McGowan precedent, which you will find in every treatise, in every horn book out there? Cool. Then let's move on to more interesting stuff, which is Laporte versus Blum. And this is going to be the options and recital of consideration. Elizabeth, would you mind setting it up for me, please? Thank you.
So Laporte v. Blum was just a word.
Yep.
In a family dispute wherein the grandparents owned a sugaring farm, once they got old, they kind of stopped working on it, and the operation was taken over by their grandsons. They tried to offer to give the farm to them. They rejected that. They also didn't want to sell it to them because they didn't want to make them, because of the profits, ineligible for Medicare or Medicaid. Sorry. At some point in this, the other children, for the defendants in this case, were less than content about them running the sugar operation, and okay, yeah. Sorry. It was in the
No worries at all. By the way, why do we think that the kids were trying to take it away from the grandkids? What's the basic?
Oh, the land was supposed to go to them. It was going to be split amongst them equally, and they basically didn't want somebody else to be able to buy it out from under them, kind of. And so they offered them the option to buy it. They offered them the lease to it too, so they could keep working in the interim. And then they tried to, after the grandparents had died, they tried to then withdraw the option, and that was not legal.
And the court didn't go for it. Okay, we have a lot of work to do here. We have a lot of work to do here. First of all, it's funny, we probably should just stick with this as a matter of black letter law, but even before that, I want to nail down why the aunts and uncles are on the warpath here. Why do the aunts and uncles want this so badly?
They also said that the value of the house and everything there was much higher than the $400,000 price tag.
Right. This was during a time when things are going up fast. Kristen, you were going to say the same thing?
This is Alexander.
Oh, sorry. Oops. You've terrified me, and you've moved, and I'm terrified. Okay, got you. Got it. Yep. Go ahead. So you were.
I was going to say the same thing. I also feel like they probably just feel like they're getting passed over.
So how were they, like, let's just, again, as humans, speaking as humans, right? Like humans have seen the movie Knives Out, not lawyers. What was the arrangement? Why in the hell did the grandparents do it this way? They consulted with lawyers and they set the whole thing up. Why did they do it this way if what they wanted was for the grandkids to end up with the farm?
Like, why did they go against the wishes of the defendant?
Why did they, notice what they did. They left the land in the will to their 5 kids. The aunts and uncles plus the grandchildren's mom, right? So all the aunts and uncles, there were 5 kids. Each one of them got 20% of the farm. Why'd they do that? Yeah. That's,
Oh, so when the grandchildren were to buy it, then they would get the money?
yeah, exactly. Right? So it was a way of demonstrating that no one was written out of the will, that no one was being snubbed. You have never seen fights like will fights when like Uncle Fred feels like he's not gotten his fair share. Let me tell you, he will tell you about it and he will hire a lawyer. So in order to avoid that, you notice they were going to give the land to the kids. Probably should have. Probably just should have straight up done it. But they did this instead because they wanted to have this kind of taking care of their children, but then also keeping the sugar farm going with the grandkids. So that's why they set it up this way. And of course, now we can see, you're absolutely right, why this is happening. It's because the option price is way lower than the actual price. And now we have to have a conversation about options. Because it shows up on the bar exam, it shows up on my exam, and it's a particularly testable, nasty one. If I go into a car dealer today, and the car dealer says, hey, I'd love to sell you this Dodge Challenger, and I'm like, yeah, that's C-Max, I am done. And I'm feeling in a deeply economically irresponsible mood, so I'd like to buy a muscle car. But I'm not sure because, like, you know, my spouse and my kids, like, they might also need to eat. And so, like, maybe, and the guy says, okay, look, you know what? I'm gonna hold it open for you for a week. Why don't you think about it? I'm gonna hold it open for you for a week. Now that's called an option. That's an option. Well, same thing for stocks, same thing for, I won't ask you to raise your hand. I did. How many of you applied early decision to university or college? Don't raise your hand, but I certainly did. To both the University of Chicago and Swarthmore, I applied early decision. They took me, I was like, I'm done now. I'm not actually checking the rest of these. All right, that's an option. My option was, if you say yes, I'm committed, you're not. Right? What's the problem with options given everything we've just talked about? Yeah, it's a conditional promise. And it's not only a conditional promise, because conditions are fine, termites are fine. What kind of conditional promise is it? Yeah,
It's exclusively on the whim of one of the parties.
yeah, it's within the framework. So Swarthmore College can choose to take me if they want to. They're not bound by my early admissions, by my early decision move. They're not bound by that at all. They just, if they take me, I will come. All right? Same thing with the car dealer. Same thing with the car dealer, although I am about to damage your mind. Did anybody catch me? And they're like, what's Professor Fairfield's up here blathering again? Nobody caught me?
What's in it for the car dealer to make that option? Or
Before I hurt you any worse, go ahead.
I mean, the card's available. Is it available at the same price?
Oh yeah, he's holding it open at that price. He is committed. I am not. Dun-dun.
You gave no consideration.
I gave no consideration. It should be unenforceable. I am here to tell you, write it down because they do this enough. If a merchant in goods of that kind, that is a computer seller who sells computers, or a car dealer who sells cars, if a merchant in goods of that kind makes an offer to sell and puts it in writing, then it is enforceable for up to 3 months without consideration. Where did I find that rule? Aha, you see it? Every time. Why would they do that? They did it again, just like Eastern Airlines. They changed the rules again on us. Why?
Well, in my sense, it's good for the merchant to advise your attention, and your potential, it keeps them in your mind.
Right? Which makes options this hardcore version of our illusoriness problem. Because every time you look at options, you're going to have two thoughts go through your mind. One, that is illusory, right? Two, and then we're going to talk about this, and then I will give you the thing to do on the bar exam. Okay? Because they will do this to you. I swear they will. All right, but first we got to get into it. The UCC changes that rule. Go look it up. It's it's 2205. They changed the rule. What's called a firm offer. That's the firm offer rule. A firm offer by a merchant in goods of that kind is enforceable without consideration for up to 3 months. They give that option. But here's the problem with saying the merchant gets something. Nate, what does the merchant get?
Your attention.
My attention. What did I get by applying early decision to Swarthmore College? What did I get out of it? I'm bound, they're not. What did I get out of it?
Get to know a little earlier.
I get to know a little earlier? I mean, that's what I thought. I don't know if it's true. I still don't know if it's true, right? Right? But that's what I thought. What's the tech? How does this make this hard when you're talking about options? This also reflects the court's thinking and why court's thinking has changed over time about options.
Oh, sorry, I was going to answer the previous question. But I mean, if you are that committed to something, then it, like I said, raises their attention and potentially increases your odds.
Yeah, it increases your odds. Which we call what? Consideration. I do want to point out that there's two paths here. The Uniform Commercial Code in 2306 just chose to expand the idea of consideration so that a requirements contract governed by good faith met the requirements of consideration. In 2205, in the firm offer rule, they just chose to get rid of it. They're just like, we're not going to do it. We don't need consideration. But it's not because you couldn't argue that there was really consideration there. And I'm asking this about Laporte versus Bloom because we'll see the court do both sides of this. One, he'll say, I don't need to ask about consideration. And that's black letter law number 1 for Laporte versus Bloom. If you want to write it down, go ahead. The court will not inquire into the sufficiency of consideration. The court even won't inquire, in most cases, into the existence of consideration. And we need to figure out why, but that's the black letter law. A recitation, what's called a recitation, a bare recitation of consideration, is enough. But then notice what the court did after that. It went and found real
Consideration because the kids kept staying there. They're going to continue to hunt.
So the court goes and finds what each party in fact got out of the deal, right? And says, oh, by the way, like not only do we not even inquire as to whether or not there is consideration or not, that's Restatement 87.1. But also, we just say, you said there was consideration? You recited it? We're done. But the other thing they did was they went and found it. And that's the point that I'm making about all options. This is why this is such a nasty area for students. Because all option contracts are functionally not supported by consideration, and yet we use them all the time because the person who makes those firm offers is getting something out of them. And if they're getting something out of them, then it sounds like something for something again, isn't it? So we get this phenomenon where consideration kind of is like this hard line, bargain for exchange, bargain for exchange, bargain for exchange, until it no longer meets the industry practice for how people bargain and exchange. And car dealers make firm offers all the time, right? And it's to their interest. Admissions departments accept firm offers all the time because it's in their industry best practice. And so you watch the law twist and change what they consider consideration to be in order to give force and effect to what the people are doing there. Now, one last damn thing. When you are on the bar exam, you will notice one particular nasty kind of question. And it will be something where you can't tell whether or not it is selling a service or it is selling something that moves. Why do they do that to you? So it's common law versus UCC. And you need to decide, and half the time what they'll do is they'll do something like this. A takes their car into the shop to have it detailed with a massive glowing neon Pokemon. And there's a fight over it, and somebody doesn't end up paying, right? And the question is, so they have a firm offer. They'll say, the offer for this, the offer to detail your car is going to be for, I don't know what it costs these days, $10,000 to detail the car, right? And I'll keep that offer open for you for a week. So you'll have an option and you'll have the car detailing. Why are they playing games with car detailing? Yeah, because it's a service and it's something that moves. By the way, if you want to know the answer, upper level class, how do courts decide? They decide through what's called the predominant purpose test. Was your purpose to get the thing that moves in the deal? Or was your purpose to get the service? In this case, the service. Now that you've gotten this so far into the bar exam question, you're going to have a set of options that you can say, right? And usually what will happen is you'll either have to fix the problem or they'll put this in one of the options. So to be clear, if this is a service under the predominant purpose test, and one party has said, I will detail your car for $10,000, come back in a week and tell me if you want me to do it. And the person goes and looks around for a week, can't find a better price, comes back and says, okay, do it. And the guy says, I'm not going to do it now. That's your setup. What's the way that you fix it? First of all, is that enforceable? Is that contract enforceable? The option contract to have it detailed for $10,000. Is that enforceable?
Maybe not the labor, but the material.
Remember we just did that? The predominant purpose test says it's going to be one or the other. Which did you want? Which did you want out of the deal? Did you want the car? That you wanted when you went to the car dealer.
I would say the service, because that's harder to do than buy a Pikachu on Amazon.
Right, which is what we just said. So given it's the service, then Liam, give me my answer.
Then we're going under the restatements, and so it is not, you can't enforce it under the restatements.
Yeah, it's unenforceable under the restatement, and they do this all the time, right? You can see that option contract would be perfectly enforceable if it were made under the UCC under 2205, and it is not enforceable under the restatement. And that's a very specific area of law, and that's why I'm mentioning it to you, because they test it all the time. And now we're going to come full circle, because I'm going to keep using this point all semester long. How do you fix it if you take your car in, and they say, to have it detailed, because you need that Pokemon, and they say, look, $10,000 my price. I'm literally doing this right now. I am having, the torrential rains recently washed out my driveway. It is now like Hoth. It is a post-apocalyptic war zone getting up there are gullies involved. You know that plastic shield underneath the Ford C-Max, that plastic shield that shields the bottom of your engine, right? I ripped the whole thing off because my wheel like tumbled off. That's how bad my driveway is right now. People are regularly showing up to fix to give us quotes on the driveway. Can I enforce any of those quotes? If I wanted the option to, and I wanted to be able to say, that's a pretty good quote. I'm not sure yet. I've got 4 more people coming, but that's a pretty good quote. I want to be able to hold you to that if I decide to. What do I do? Yeah.
Submit a deposit.
Submit a deposit. That is consideration. Not for the driveway, but for the option. The way you solve the problem is pay for the beeping option. How much? And I swear to God, it's going to be $14,000 maybe, and those are good prices, to get this damn driveway paved, because I am done with this now, right? So it's $14,000. How much do I need to pay for the option to make sure that nobody gets away with it?
$10 because it's just the formality of it.
$10 because it's just the formality of it. I was going to go with, though, $1, but come on, like it's this class. Lucy versus Zamer. We're going to go with $5 just to make the point. All of these numbers are right? What I need you to do is I need you to see, when a court does not enforce the sufficiency of consideration, when the court does not inquire into the sufficiency of consideration, sometimes you will hear this stated in old textbook as the peppercorn rule. When those of you come up to my office for questions and whatever, you will find I have like this pepper grinder in my office because one student gave it to me because it was the peppercorn rule. Consideration of a peppercorn is enough. Technically, I could just say, keep this option for me, I'll give you a peppercorn. Any consideration is good enough because, why? Why is any consideration good enough? Because the court doesn't look at the sufficiency of consideration. And why does the court not look at the sufficiency of consideration? It creates the form of a contract, and?
Because it's subjective.
Because it's so fundamentally subjective, there is no damn way they can tell. There's no earthly way they can tell if it's worth it. Maybe it's a special peppercorn. Maybe it's like the peppercorn that, I don't know, like your favorite celebrity, Taylor Swift, used this peppercorn once. And you're just like, ah, right? My news feed has been full recently for reasons that are entirely outside this class. All right, you see the point? That's what's going on here. And it's also a nice split. So if you get the option on the exam, usually what will happen is you'll go, oh, I see this is a service contract. Therefore, this is not supported by consideration. But then you'll look in the facts and you'll be like, yeah, but they made some other promise, like I'll pay you $10 for it. And at that point, you're like, you no longer need the rule of 2205 to enforce it. The big way they do it, and just write this one down, asterisk it, and it'll come back at the bar exam, is they'll have 4 months go by. It will clearly be under the UCC, but they will have 4 months go by. Can you see how that works? It's only enforceable. Firm offers are only enforceable for 3 months. So they're testing everything all at once. They're testing if you know 2205. They're testing if you know that firm offers are binding without consideration, but then they're punishing you for knowing that because they're sneaking the date in and having the date be longer than that 3 months where it's enforced without consideration, which means you're back to the old restatement rule. You're not under the UCC anymore. And then they do the final twist, where if you paid for it, though, you don't need the UCC in order to enforce it. There was consideration. That question, I'll take you out to lunch if that question is not on the bar exam. And I have never been taken up on that particular offer. I'll take you out to lunch otherwise, but like, I've never been taken out to lunch. I've never done. It's never happened one time. Everybody's like, yep, that question was on there. And sure as hell's on my sales exam. So remember that for next year. All right. Any questions about Laporte versus Blum? I guess a few more things that we need to kind of unpack here about Laporte versus Blum. Let's just make the black letter law of it all kind of real straightforward. Elizabeth, what are the two things the court says about consideration? The black letter law here.
The black letter law that the like $10 consideration that's written into the contract
Yeah.
has like never really been paid attention to.
Yeah, that is, what's going on there? They say nobody has ever noticed. There was that line, the attorney who'd been involved with this had been doing this for years, right? Yeah. And what did he say? I've never seen anyone hand that $10 over. They're doing the Lucy versus Zamer thing. You notice that? They're doing the Lucy versus Zamer thing.
So let's say this driveway thing is happening in your situation, and you have an agreement set up for next week, and they're going to start it.
Yep.
And they just fail, but you haven't like paid anything. Like, if you sue them, like, what are you reclaiming? Like, what are you getting back from them?
We're jumping ahead, but what do we need in order for me to enforce a promise that hasn't been made yet?
Signature.
Signature? Is a signature what you need for a contract? It is, by the way, to be clear, it is, but we need to know why. What's up with signatures? Everybody thinks this. Humans think that signatures are required for contracts.
I thought there was like a statute of fraud.
There is.
Only sue on the, like, against the person who has signed a contract.
Bingo. Here it is. Our 5 questions in this class are, is there a contract? In this case, is there a contract? Yeah, what forms that contract? Offer, acceptance, and consideration. That's called an executory contract. It's a contract that I haven't paid for and you haven't done yet. But, can you see it's still a contract? I promised to pay you $14,000. You promised to repave my driveway. We're done here. Offer, acceptance, consideration. Is there a contract? That's question 1. Signatures and writings are what question? Formalization. Certain important contracts, not all, but certain important contracts are only enforceable past the statute of frauds if you have a writing signed by the party who's about to get sued. That is, the contract exists, but is not enforceable until some contracts for land, contracts for services over a year, and a few others that we will study, right? Some contracts are not enforceable until you get it in writing and you sign. But those are formalization requirements. And you're right, you have to have them we'll see that in Orion, right? That's the whole problem in Orion. They had a deal, thinks the court. You're pretty clear the court thinks there was a deal. They had a deal, they didn't have it signed and in writing. And it was one of those cases where you needed it to be signed and in writing in order to enforce it. Not to have it, but to enforce it. Okay, cool. Second thing then that the court says about consideration, the first one is a recitation of consideration is sufficient. That's restatement 87.1, black letter law. What's the second thing the court says about consideration?
An option, is a continuing offer, if it's supported by consideration, it cannot be withdrawn before the time limit.
Right, and so what's it saying there about the option? It's saying two things about consideration. One, it's saying we don't, what is the consideration for this option? One, that's the second one, absolutely. So two, the continued working on the land is also consideration for the contract. One, what was consideration for the contract? The recitation of the $10, exactly right. And so you can see the sort of belt and suspenders approach that we've got here for the two kinds of contractual consideration that the court's looking at. All right. Any question on Laporte versus Blum? Yeah.
How do you think they would have ruled if there was no resuscitation of the $10? Do you think they still would have given?
I think they still would have given it to the kids, because I think it's clear that that's what the grandchildren, it's clear that that's what the grandparents wanted. By the way, what else am I going to say about this case? And I'll say it like half the time because I teach another class next semester. It's a failed will again. What do you call it when you want to leave property to certain people and not others after you're dead? You call it a will. Holy. You call it a will, you get it signed, you get it signed, you have an attorney go over it, you have people who are witnesses. Don't do this. All right, that's one part of it. You had a hand.
I was wondering if the lawyer's argument that they've never seen anyone exchange the money is kind of an example of industry practice.
Oh, absolutely. It's our industry and practice. And if you think other industries give their practices meaning, force, and effect in legal terms of art, our practices are the version of that on steroids, right? We really define what legal terms of art mean, and our practice really defines what terms of art. So yeah, I mean, I think that's a big part of it, is that this was just standard practice. You will see this in so many contracts. They just have this recitation. I would still probably have them hand over the $10. Why not? It's so powerful under the modern common law, but you don't have to. I have more. I've got one and then another. Yeah.
So this can probably be explained very easily by the fact that it's different courts. And this is spoilers for Carlisle.
Yeah, we're going to get there in a second. This is the first question I'm going to ask, but keep going.
I was going to say, why
I know.
doesn't the court here say their previous work counts? But okay.
I'll just let you ask that question as the first question when we get there, because that's going to be it. Yeah, go ahead.
If this is something that's going to create a tangent, then it's,
I will stop.
I have a question about back to the intent.
Yes.
Is that not that seems like more of a sentimental value to me?
It is. Oh, it is. If I asked you, and I did, because it was on one of my policy questions on one of my exams, and I said, the objective theory of contract is fundamentally incomplete. List all cases and analysis throughout this course that show that courts, in fact, pay more attention to the subjective intentions of the parties than the objective manifestation of their intent. Would you include Laporte versus Blum as one of those cases? I would. Why?
Because of that intent part where the grandparents intended their grandkids.
I think it's related to your question. Is the court going to do this anyway? Yeah, the court's going to do this anyway because it's a failed wills case and because the court's trying to do what he thinks these sort of innocent grandparents really wanted out of their life. Let me give you the one place where the court's gesturing towards it, where a recitation of consideration is not going to work. The parties hereby agree for a recitation for $10 and other good consideration. You notice they put that in there to invite the court to do both, right? To not only look at the $10, but also to look at the work on the farm. So for $10 and other good and valid consideration, the validity of which is expressly acknowledged by the parties, they all put that in every contract ever. We agree that I will have an option from you to buy Bitcoin at $10,000. I heard it. What the hell's wrong with this picture?
It's a really good deal.
Is it a really good deal? Is that a deal? Courts won't ever inquire into the sufficiency of consideration because they can't tell whether the glasses are worth the $17.99 or if the $17.99 are worth the glasses. But you can tell me absolutely clearly whether or not Bitcoin is worth more or less than $10,000. It is worth more, by 10 times at this point. That stops looking like something for something. Like if I say, for $10, I give you the right to demand $100,000 from me. You see that? The court's not going to touch it. That's what the defense was looking for here. They were trying to say the farm was like Bitcoin. It was going to be, the option was way too low for the overall cost. Now the court compared the option price at $200,000, and that's right. But imagine if they'd only ever just paid $10 for the option. The option itself would be worth so little. Like, imagine you had an option to buy a house now for $200,000. Do you want that option? Is that option worth more or less than $10? More. See, at some point the court's like, I can't tell. Like at some point their system kicks out. And it's usually when the thing you're paying and the thing you're paying for are basically the same thing. Money for money, right? The court's suddenly like, no, like I get it. The glasses might be worth more or less to you. The car might be worth more or less to you. But money is worth money. And so when you pull this stunt, a bare option for monetary return is often the place where they test this rule of consideration. If on the bar exam they want you to say, okay, I'm done here, that option is not cool. That option is for way too little and it's worth way too much right now. And it's usually when it's money for money so that the court doesn't have a problem comparing things. All right?
What is the name of the concept
Which one?
that you're describing right now? Fair option. This mispricing, right?
Oh, this mispricing. A bare option is pretty good. The court goes into it. They don't really have a word for it. The court goes into it in the 200,000. You notice that the defendant's really screwed up here. The court's like, I don't know what the farm's really worth. First of all, go get an appraisal. That's an attorney's failure. And second of all, at some point, if the land had been worth $10 million, you start thinking that a $200,000 option for land that they know is worth $10 million might invoke this money equals money rule, and the court might begin to go, I'm not going to enforce this as a free option just for fun. Yeah.
In the context of a family member selling to another family member, would the court be
Likely to do exactly what it did, which is take as consideration the family bonds, the need to keep the farm open, all of those other things that they wanted, because that's not money for money. You notice that? The court gets this money for money argument happened in there. Like, look, this is an option for $200,000, and we know the farm is worth 5 times that. Like, we can just assume the farm is worth 5 times that, right? So this is a weird option to just give people for free. And the court says, no, I'm not gonna, one, I don't know how much the farm is really worth. Go hire an appraiser, man. Like, that's a supplemental filing. We get that done in 15 minutes, right? But then two, the court goes and finds all of this subjective, right? All of this, how do I feel about it? I want maple sugaring to continue to happen on the prop. Goes and finds that whole sob story to support it in the alternative. And I think your intuition there is right. The court's going to absolutely do that in this failed Wells case. Yeah.
So would a better defense, if the facts presented do say the brothers are just going to turn around and sell it for this amount of price? Like it's ultimately, they don't want the land. They just want
I'll guarantee you that would have been a weaker claim. And if I were their attorney, I would say, do not say that is what you're doing with the land. No, instead say you are creating, the Burgess named after them, Cozy Core, Sugar House, grandma in memoriam property, right? That's what you're doing. That's what we're doing on the land, Your Honor. We're certainly not selling it to make a subdevelopment. Anyway, I saw some other hands. I know I've missed some people. I want to make sure I've gotten people who had their hands up. Anybody? Okay, cool. Yeah, go for it.
Sorry, this might be a tangent, so don't. But you said like money for money. That's only
And then, so, for example, if it's an option contract now that in the future may be worth nothing or maybe worth a lot, we're back to our old expanded idea of consideration. You're paying for a chance. And paying for a chance is fine. And so you can see how this just gets incredibly hard, right? All right. Bottom line, in your practice, a recitation of consideration is just fine. Okay, that's Laporte, Carlisle. Moving on. And Nate, would you mind setting it up for me, please?
All right, so Carlisle versus TNR Excavating. We have a situation where Mr. and Miss Carlisle are married, and Miss Carlisle wants to start the Wishing Well preschool for reasons, and her husband is also interested in this potentially for his own long-term retirement. He offers to, using his construction company, to build a preschool, which is about $40,000 in labor and about $30,000 in materials. And they sign a proposal, and then soon after they sign a provision because their marriage is struggling and they're starting to try to hash things out, who's going to take care of who. And they change this agreement where now Ms. Carlisle will pay for the materials, whereas TNR is covering the labor and the construction, Ms. Carlisle is covering the materials. And then there's a contractor agreement that is never signed by Mr. Carlisle and TNR. But they still start work, and they work until June, at which point they abandon the contract, and Ms. Carlisle hires new contractors to finish. And due to this kind of nebulosity, the opening was delayed by 1 week. It's supposed to be like middle of August, end of August it opens, and Ms. Carlisle sues for the cost of new contractors and the delay in
getting it done. Okay. Now, before we kick the living tar out of this decision, what is the black letter law of the decision?
The black letter law said it was a gratuitous promise.
It was a gratuitous promise. Why was it a gratuitous promise?
Because Mr. Carlisle and TNR stood to gain nothing from this option other than good faith from his spouse.
So there's a couple of problems with consideration. Here's the first one. Stood nothing to gain. Where have we heard that before? Hamer versus Sidway in its old statement of benefit and detriment, and saying got nothing, has nothing to gain, did not give anything. I told you courts get hooked on this Hamer versus Sidway crap and keep coming back to it. This is a good example of it. So the court already doesn't understand what consideration is, which is where we're going with this. And I'm going to ask you for your question here in just 1 second. So they've already got this benefit or detriment thing. What's the second reason why there's no consideration here? And it's sort of hidden in the case, and it's also deeply bullshit?
Was this the past consideration doctrine that she used to work at TNR, I forgot to add that.
Right.
She forbore wages voluntarily as kind of an act of goodwill.
Right. So that was just actively stupid, right? Where they said, based on the stuff that happened in the past, we're going to put that in our present agreement to build the school. That's just called the lawyer being like extra dumb that day. This lawyer's got a lot to answer for. Don't worry, we're getting there. But the court blew that one. What's the third ground? There's a sort of hidden subtext that makes my teeth itch.
The relationship.
Okay, what was that crap?
Well, they said because it wasn't considered consideration because they were in a relationship.
Because it wasn't considered consideration because they were in a relationship. Why?
Because their finances were considered one. If she gained from the school, then he would also gain from the school.
This is like when somebody, makes a racist joke and you're like, what did you mean by that? And you just ask them, what did you mean by that? What did you mean by that? So I'm going to say it again. Why are their finances one?
It said directly in the text, and I put this in quotes, one is entitled to their spouse's earnings.
One is entitled to their spouses. In what universe? Why? What's the theory under which one is entitled to their spouse's earnings? And that's not how the rule was originally put. And this is also why your spouse cannot be compelled to testify against you in court. The traces of this are all throughout our history. Why?
Is it because technically the agreement wasn't bargained for, it was for the mutual benefit of both parties?
That's what they say. It was for the mutual benefit of both parties. That's an actual real argument, right? You can imagine, can I charge my spouse for mowing the lawn? I mean, first of all, let me be very clear. I am the massive beneficiary of my spouse's tremendous competence, and I'm not about to upset that boat. But second of all, I could, for the benefit of the relationship, if I do, I mean, this actually happened the other day. My spouse came to me. She's the executive director of the Charlottesville Oratorio Society, and she had some legal stuff, and I said, well, I can't do it because I'm not a Virginia attorney. I'm an Ohio attorney. So unless you're like an international, like an interstate consortium, I can't really do that. But second of all, like if I'd have charged her organization for my work, I don't think any court in the country would have said I can't do that. Something else going on here, y'all. Oh, is it because marriage is a contract? It became a contract, and by the time we hit this case, courts are treating it as a contract. Why can't you compel your spouse to testify against you? Dun-dun.
Is it because when you're married, you're considered one?
Uh-huh.
And you testify against
There it is.
one, it's, I forget the term, but you can't testify.
You can't, it's literal, right, it's literally the rule that you can't be forced to testify against yourself, and under certain religious frameworks, that was considered to be one person. Now tell me this denatured and changed up language, you are entitled to your spouse's earnings. Where's that coming from?
Well, just to return to your lawn mowing, imagine you go into the house, you go to the cash jar and take out $50 and go give it to your wife to mow the lawn, or she does this to you, and then you just go back and put it back in the same jar.
So that's the argument. The idea here is you can't contract with yourself either.
Yeah.
Right? Now, this is profoundly problematic. In fact, we had whole revolutions in law to change this state of affairs, right? What were some of the other outcomes of this change of this state of affairs? That a married couple were considered to be one person. Single-party divorce laws. This is coming up, and this is going to be this is not a failed wills case. This is a failed divorce agreement case. So this is all about the fact that the parties were married. It's absolutely right. Yeah.
In order for the contract to go into effect, they needed to actually separate at the time they signed it. However, they were still living with each other for a few months after they signed it.
So they were still living with each other. They were separated. The court makes this relationship thing the big deal, right? And says you're not allowed to contract with yourself. By the way, that has not been the law for 100 years now. It turns out that both spouses in a marriage can own property these days. One is not legally subordinate to the other. Those were all part of this same rule that said that both people were the same legal person. There's one upshot from it. There's one really positive part of this. I use this rule all the time. It turns out if I go out and crash out there on 81 and hurt somebody, they can't come and take my house because my wife and I hold our house by tenancy by the entirety, which is a form of property ownership only available to married couples. And the rationale behind it is we are one person, which means that if I'm over here and I damage my part of it, my wife's part of it stays entirely intact and is completely free from being encumbered by what I do. So there are some ways that this rule works out. The court makes this whole thing a big deal, and this is now finally where I get to your question. What's the contract we're actually talking about here? Yeah.
So I guess we're taking that rationale, and theoretically that means that the ex-husband did the work himself because it was his wife.
Well, that's what the court starts with. The court says that each party, she was doing the accounting and he was doing the building for himself. She was doing the accounting for herself. He was doing the building for himself because of this ancient legacy idea that they're one legal person. No longer true in any respect, but you can see traces of it throughout our legal system. So, right, You've got this framework here. That's what they've set it up as. What's the relevant contract here? What are people writing things down for and signing them for, or not signing them as it turns out, for? Is it just the agreement to build the school? Yeah, it's a divorce settlement. What happens in a divorce settlement? That is stuff we already have. Look, can I give myself my glasses in consideration of a contract? There's two reasons why that doesn't work, right? One, it's me to me, and two, it's already my stuff, and so I'm not getting anything, right? But when the parties are separating, can you see that all that stuff that they had in the past now becomes stuff that they're bargaining over? What's the thing that gets fought about more than anything else except for the kids? The dog, right? Do you think saying, you get the truck, I get the dog is not something for something? That is something for something, right? I agree on this stuff over here, you agree to build the damn school, is very much something for something. The court lost sight of what the real contract was. The contract was a divorce settlement. And what it did was it endangered the entire process of divorce settlements. Can you see how its rationale means that all divorce settlements are completely unenforceable? That's nonsense. This is not the law. This case is wildly wrong because it mistook what the contract was. I need you to see two things, therefore. I need you to see the black letter law. Why did the court say you can't have a contract with yourself and past consideration doesn't count? What you did in the past doesn't count. But then it lost track of the fact that we are now having a new deal. These parties are legally separated. We have a new deal now in which the parties are trading elements of their past lives in order to try to untangle it. And that is absolutely something for something. And so the court just, in its effort to say everybody helps out in a marriage, and of course you don't draw a salary for it, which, is kind of true. Everybody help. It's actually not true, by the way. If your spouse contracts with you to perform a service for a price and you do it, you can sue them for breach of contract. Like, that's nothing that the court says here is true. But furthermore, the court endangers legal settlements through its completely failed interpretation of what consideration means. It just had the wrong contract in mind. Yeah.
In the case, it says that the separation agreement was voided because they didn't immediately separate.
Right.
Is that still currently true?
Sure, the settlement agreement is voided because they didn't separate, but their deal isn't. I mean, they can say, yeah, that's not been enforced by the court, but if we've got something for something, we can just have that be a contract, just on its own. And what you need to understand was they were swapping things in anticipation of ending this stuff. That makes it something for something. If you want to not enforce it because you need it to be properly agreed upon by a court so that the court can check that the settlement's fair, that's a valid reason. But you shouldn't knock it out of consideration. Consideration's the wrong doctrine here. So yes, the settlement agreement was void, but that doesn't mean that there wasn't consideration here, which is what the court rests its decision on. There was consideration here. If you want to not enforce it, don't enforce it for a different reason. Okay? That's a really good question. Yeah, look.
Didn't the settlement agreement say it was specifically her services for doing
the agreement was written by an attorney who, why would you even do that? Just say, we are divorcing. This is the breakdown of the exchange of everything for everything. That is, of course, consideration. There may be other problems with it that make it unenforceable, but that's, of course, consideration.
So this is a gratuitous, if they were married, you could say this is a gratuitous promise, but once this construction action is codified in the divorce agreement,
Yeah. Then it's a non-starter. By the way, I also think if you push on the whole idea that you can't contract within a marriage, you will find that's flatly false. It's just wrong. You can contract within a marriage. What? In what world can't you write an enforceable contract? It might be that courts say many arrangements are just purely reciprocal and they're not contractual. And for those of you who are still out there in the dating market, a transactional relationship is really not how you want to be doing these things. I get that. I'm here with you, right? That's one of the first red flags. Do people consider this to be transactional? Okay, walk. But But there's no legal reason why you can't sign a contract with your spouse. We are, in fact, separate legal people these days.
This is a little bit like outside lines, but like how does a prenup work then? Because if you're becoming one after, does it just work because we're individual people?
There is not a present legal principle that a married couple is one person. There are traces of that throughout our law. Your question's a great one. It is yet another example of why the court's reasoning here just absolutely doesn't work. Okay, final question, yeah.
I was gonna say, like, does this have, so they're saying, the court says it doesn't have elements of consideration. They're missing the whole point that it does because of the divorce agreement.
Yep.
What if there was no divorce agreement? Are they?
The past consideration, I think, would be absolutely unenforceable despite my pontificating. The relational component of it, I think, would also not be a part of it if you did it right. Let me ask you a question. Why is it that her paying for the materials is not consideration for the contract?
Because technically it's part of the bargain, she's continuing it.
Right? If I say, if you meet me on Tuesday, I will take you out for lunch. Is that a bargain, something for something? No, it's not. I didn't want something. It's a condition required for the promise to be fulfilled. If you pay for the materials, I will build it. They're not bargaining for you to pay for the materials. They're saying, if you pay for the materials, I will build it. Let me ask you a nasty question, though. If you come, let's see here. If you come to Lexington, I will pay, I won't. If you come to Lexington, I will pay for your tuition at W&L. Make that a condition, because we're lawyers. We pull this lever both ways. Make that a condition. It's no consideration for the contract. Tell me the story.
You want it to be a condition, so without consideration?
Yeah, I want it to be conditioned so without consideration.
Lexington, without any struggle, monetarily or time-wise, then it wouldn't be consideration.
Yeah, so you get to Lexington. It does cost you, but I didn't want you to come to Lexington. It's just a necessity for you to go to law school here so that I can pay your tuition, right? It's a requirement. It's a conditional requirement. Give me alternative facts that make the sentence, if you move to Lexington, I will pay for your tuition at W&L, into a bargain for exchange.
You turned down an offer at another university.
They want me to come to Lexington. That's what they're bargaining for, right? So that's one that's really common. Keep an eye on these if blank, then blank. I think that's how that contract would work out in the absence of the stunt that the court's pulling here, is it would go look at other components of consideration, other ways that we've stretched consideration. I think it's right that past consideration is not present consideration for a new deal. If the parties are distinct legal entities, the fact that I've worked for you in the past does not support your promises to me in the present. Full stop. Right? Similarly, the relational stuff, I think we can just see through a broad range of examples is nonsense. Then we get to the conditional stuff, and maybe we get to some arguments there, right? Like maybe the if you buy the stuff was somehow bargained for rather than just simply a precondition to getting the deal done. Yeah.
What if the consideration is their presence, like a celebrity or like an athlete or something?
Yep. Could easy be, commonly. Or, but the version I loved, turned down an offer somewhere else, but the easy one is, your grandma wants you here in Lexington. That works. Perfectly good consideration.
Wait, so, I'm sorry, that doesn't matter for the lunch thing then.
Oh, I know. But see, the difference is, do I want you at Blue Sky Cafe? Is that my goal, to get you to Blue Sky Cafe? Is there a reason why I need you at Blue Sky Cafe? Or is it just a requirement before I can pay for your lunch? Is that just a condition? If you think that these are easily distinct, if you are confused, good. Take your confusion and turn it into your superpower as an attorney. What you've just realized is that when you see one of these conditions, you can turn it into bargain for exchange if you want to. And if you don't want it enforced, you can turn it into a condition if you want to. That's your superpower. It's not confusing. It's where you win, no matter what happens. Just remember, it's either one, and remember, oh, I see, I can think of it this way. Boom. I can think of it that way. Boom. Carl Llewellyn, the great drafter of the Uniform Commercial Code and one of the preeminent contracts and commercial law scholars in the world, said the defining characteristic of a lawyer is the ability to hold two mutually conflicting ideas in your mind at the same time. And that's what this is. Is it a condition or is it a bargain for promise? I don't know. What's my client need? That's what I'm going to argue, and I'm going to do it well. All right, yeah.
One question I wrote down, specifically with the restaurant example, is that if someone's asking me to spend time with them, does my presence not provide some?
If they want your presence, if that is what they were bargaining for. If they don't care and it's just necessary for them to do the thing, no. If it's what they were bargaining for, yeah.
I think that's just an argument.
And then you just make those arguments. Right. It's not like yes, no. It's make the argument. That way you can win either way. Yeah.
But isn't that like super subjective, and the courts don't even usually like that, so how are you going to even prove?
Yeah, the answer is you argue it. Like, and you argue it strong. You provide other evidence, right? You're like, look, Professor Fairfield was just making a point. It turns out he didn't really care if Fred came to lunch with him. He just said, this is a condition. If you come to my office, I will answer your questions about contracts. Now, I adore each and every one of you, but I am not bargaining for your presence. Right? You get the difference? Now, what is that? That is an argument. It is not a state of affairs that is verifiable in the universe. It is an argument. And then you start making, what's the counter argument? The counter argument is, I had just said, you made a really interesting argument in class today, and I think we can make a business model out of this that's going to be worth $1 billion. Why don't you come up to my office afterwards and we'll talk about that. At that point, maybe your presence is in fact bargain for exchange. The hearing your idea is maybe bargain for exchange. I'm not saying what's right and what's wrong. I'm saying that's what the fight's going to be. And that's how you're going to argue it as your lawyer. No matter what side you're on, you're going to pick one of those and you're going to argue it. And that's what I said at the beginning of the class. If the subjective framework doesn't work, you're the one arguing objective. If the objective framework doesn't work, you're the one arguing subjective. That's how you win. Yep.
TNR, if Mrs. Carlisle had, in addition to buying the supplies, also given $5
Yep.
on top of that to TNR, would she have a consideration claim? So it's like not just back to zero, it's like 0 plus 5.
She'd really be pushing it, but if she'd have paid $5 for the deal and paid it up front and said, the price for this is really $5? And he's like, yeah, the price to build the school is $5. And she gives him $5 and it's on video camera and they hash that video to the blockchain, yeah. Courts do not inquire into the sufficiency of consideration.
Just to get back to 0.
Okay, let's move on. We're going to do D&G here, and D&G is a rough one in Midwest Energy. It does mean we're going to run over a little bit, but that's fine. I'm going to ask Graham if you wouldn't mind setting up D&G for me, please.
Yeah, so there's basically a plaintiff brought, the plaintiff Midwest brought suit against the Orion company and then a sales representative for that company. Because basically the representative had offered was sent an unsigned franchise agreement to the defendant with a specified opening date. And then the sales representative says he'll pick up the contract at a specified date, doesn't pick up the contract, becomes unreachable. And then basically the plaintiff then signs and mails the order to the defendant. And then a representative for Orion informs that there is no execution on the agreement and letter informing of that no franchise agreement.
All right, on the franchise agreement. Okay, cool. So first of all, let's and I know I've jumped Ricketts, so we're gonna come back to Ricketts here in a second. What's the argument that this franchise agreement or that this distributorship is that this is not a contracts case? Because we've now shifted into a different area of law when we're looking at Ricketts and the rest.
The argument is basically that there's a reliance created from the promise, right?
That there's a reliance created from the promise. So the idea is the liquor store asks Bacardi, are you going to pull your distributorship? Bacardi says we're not, then what does the liquor store do in reliance on that promise?
The liquor store then offers to, Reliance the promise turns down a sign or turns down a deal.
Right.
And walks away from an offer to be bought out.
Okay, walks away from the offer to be bought out. Okay. That's where we're going to end up. But I wanted to start there before we kind of back up a second and do Ricketts. I wanted to start there by saying, what's the real story here? Was there an agreement in this case?
There was no signed agreement between them.
There was no signed agreement. Does there need to be a signed agreement in this case? Why isn't this a contracts case? It's at-will relationship. Does that necessarily mean it's not a contracts case? It does not. In what circumstance have we seen an at-will relationship result in still we're doing it under contract doctrine?
The lumber case.
Yeah, Columber, right? Like Land versus Columber. That is labor cases. So the fact that it's at will doesn't immediately mean that this is a failed contracts case. It just might be a contract. We've got a contract. It's just it's always going on. And one more day is our rule, right? It's always going on, and every day both parties have to agree to continue on with it. The reason that I point that out is because it's going to happen all the way throughout. So, Graham, and I know this is unfair, but can you give us a quick recap of Ricketts? What's going on in Ricketts?
Yeah, in Ricketts, it is that basically the grandfather gives a promissory note to the granddaughter saying, if you stop working, I will, or not, but there's no quid pro quo, says, I will give you a note, or, and you can have $2,000 per year and then basically she quits the job, takes over worst position for a time being, and then basically he dies and she sues the executor of the will for
money.
Basically continual payment.
Payment, okay. Anybody have a problem with this case and get real confused when they read it? Raise your hand if you think you can win this case. There was a contract, it was fully supported by consideration. Go for it.
Well, the grandfather wanted her not to work, and that's why he gave her the contract, so there we go.
Yeah, it's like the Burgess grandparents wanted them to run the farm. If the court calls that consideration. What did they call consideration in Hamer versus Sidway?
What did they?
Yeah.
Him refraining from doing like things he could do, like.
Right, the uncle wanted him to stop smoking, drinking, and gambling. It's not like the statement, if you stop smoke, drinking, and gambling, then I will pay you a pile of cash. Right? That if statement, the question is, was it bargained for? Was it bargained for? Is there any evidence that this grandfather wanted her to stop working?
Yeah.
Yeah. What was the evidence that this grandfather wanted her to stop working?
I mean, I think there's a third-party witness who says that he said that. She's claimed it a couple times.
Also, there's some class stuff going on. What was it?
Oh, he didn't want any of his grandchildren.
Yeah, right. There's this old distinction, right, between the English aristocracy, people of leisure who don't need to work, right? Every Downton Abbey episode ever. These people don't work. They probably should. They're like down at the heels, like the nouveau poor. The aristocracy's in trouble, but still they don't work because that's their self-conception. So he clearly didn't want her to work. And he said, none of my grandchildren need to work. I'm not going to make you work either. He bargained for it. Look, my point here is, did you see what we just did there? That has nothing to do with this case. It is not the black letter law of this case. What you just did, though, was you're like, oh, the lever's over here. What? Look at this. I just won this case. I'm over here. Right? This is a fully supported by consideration case, and all we did was just make exactly the set of arguments we've just been rehearsing. And the reason that I raise that is because all of these cases are one of the lever away from just being a contracts case. In the cases that we're going to start seeing, something's gone wrong with each one of them. Now, we could call them pure, what Ricketts versus Scowthorne stands for. What is the black letter law of Ricketts versus Scowthorne?
Basically, if you create or do a promise that then causes a detriment to another individual that then they act on and it's rely upon, then
you have to follow through with that process.
All right, so I'm going to be very precise. Here's the modern rule. This is section 90 of the Uniform Commercial Code. It is the section that not the Uniform Commercial Code, of the restatement. It is probably the one section of the restatement that you should know forwards and backwards by heart, because it becomes this major patch, this way of fixing contracts that are starting to fall apart. And it says this: if you make a promise that it is foreseeable that someone else will rely on, and that foreseeability matters. It is foreseeable that somebody else will rely on, and they do reasonably rely on it, then you owe them the costs of their reliance, not their expectation measure under the contract. You owe them the costs of their reliance. Here's the standard move. If I say, if you move to Lexington, I will pay for your tuition at W&L, and somebody doesn't turn that into a contract, which they might, what would your argument be to turn it into a contract? If you move to Lexington, I will pay your tuition. Turn that into a contract. Yep.
I rejected an offer.
Rejected an offer somewhere else in order to come? Give me another reason. I wanted you there, and I was actually bargaining for you to come. It was not a condition. I was bargaining for you to come here, right? All of that makes it into a straight up contract. But if it's not one, and it's foreseeable that you will believe me, that you're going to come, and then you have your out-of-pocket costs when you come, then what I owe you is not your tuition at W&L, unfortunately. It is your out-of-pocket moving costs, the costs that you had when you moved. We have one final question. I do have to let you go, but then we'll pick this up next time.
I was gonna say, if you rejected the offer from the other school and they give you like a scholarship or something like that, would that be something?
Well, I can't answer that directly because the dean will kill me, right? I've rejected something else and then took a deal here, and da-da-da-da. But generally speaking, these things begin to make it look a whole lot more like a regular contract. So we're going to start with Ricketts versus Scawthorne and D&G Bacardi and take a look at all these cases, and Midwest versus Orion. We're going to do them fairly quickly, and they're hard cases next time. But what I want you to do is look at each one of them and go, you know, that was really a contract. Then discover what went wrong with that contract, why they're not just saying, yep, it's a contract, we're done. So what went wrong with that contract, and then how are they using these doctrines to fix broken contracts rather than to be something else? All right, we'll pick up there. Thanks, folks.